kuondolewa afisini kwa aliyekuwa naibu rais Rigathi Gachagua inaendelea kusikilizwa.
Good afternoon, Your Lordship, Your Ladyship. I appear alongside my brother, Mr. Sakimpa. We appear on behalf of the 4th to the 8th petitioners. Ab initio, we will be relying on the following documents. We will be relying on the petition dated 18th October 2024. The affidavits in support sworn on 18th October, the written submissions dated 16th January 2026, the list and bundle of authorities dated 16th January 2026, the further list of authorities that dated 25th April 2026. All power has a limit. All power has a limit. Certain values in the Constitution have been designated as foundational to our democracy. This in turn means that as pillar stones of this democracy, they must be observed scrupulously. If these values are not observed and their precepts are not carried out conscientiously, we have a recipe for constitutional crisis of great magnitude. In a state predicated on a desire to maintain the rule of law, it is imperative that one and all should be driven by a moral obligation to ensure the continued survival of our democracy. That is a paragraph from Nyathi versus member of the Executive Council for the Department of Health, Gauteng, and another 2008, Madala J at paragraph 80. It's in our list of authorities supplied, dated 25th of April 2026. My good friend, Elisha Ngoya, wandered in the morning, and I joined him in the wandering. Which way, Kenya? What is the state of our morality in terms of our constitution? We have provided a case, and that case will form my next line of submission, the case of EFF, Economic Freedom Fighters versus National Assembly, 2018 South African Constitutional Court. Which way for Kenya? The first petitioner has gone through what happened in terms of the process. It paints to us a very worrying state in terms of the health of the democracy that we have in this country called Kenya. This is a clawback in terms of the Constitution and the state of our democracy, culminating into the Constitution 2010 that was characterized by huge cost for the ordinary Kenyans. People shed blood, people were killed, and people died. We should not lose focus of that. And that state of affairs painted by the first petitioner leads me to pose this question to the court. Did we need specialized rules and procedures for this process of investigations and hearings to be established before the process commenced? Did we need specialized rules and procedures before the process of impeachment investigations and hearings commenced? That is a question, Your Lordships, Your Ladyship, this court must answer. And like my elder senior counsel, Elisha Ngoya, I'm relishing to read the answer to that question from this court. On our part, we respond in the affirmative. Yes, we must, and we needed to have specialized rules before the impeachment began, either in form of a specialized code or it ought to have been mutually agreed between the parties. Parliament ought to have sat down with the Deputy President and agreed on the rules of procedure, or else we should have had a specialized code. For the following reasons. Number one, protection of constitutionalism and the rule of law. Pre-established rules ensure the impeachment follows constitutional norms rather than political convenience or sudden improvisation. The Speaker extends it to Saturday. Parliament says no. We will do as we wish. Error. Kosa kubwa. Secondly, prevents abuse of power and political witch hunts. Clear procedures make it harder to weaponize impeachment and partisan revenge for short-term political gain. Number three, guarantees of fairness and due process. The office holder facing impeachment deserves predictable procedures, notice of charges, a right to respond, and an impartial hearing. Number four, enhances legitimacy and public confidence. When procedures exist beforehand, the public is more likely to trust the outcome as lawful and not pre-engineered. Public trust, public confidence. Next, it ensures institutional consistency. Preset rules prevent changing mid-process to suit the circumstances or the person under investigation. We are giving you, was it 10 days? Then midstream, we are going to continue, irrespective of whether you are sick or not. Rule of law questions. Can we operate a serious constitutional interrogation such as an impeachment in that manner? No, we say. Promotes separation of powers. Structured procedures reduce institutional conflict by clarifying the roles of Parliament, courts, and other bodies. Number 7, provides clarity and efficiency. Investigations and hearings move faster, are more coherent when procedural uncertainty is removed. Number 8, protects minority and dissenting voices. Those that dissent, and for aught we know, perhaps we had dissenters, people who are willing to vote against the impeachment. We may never know because the rules lacked. Formal rules ensure minority members in legislative bodies can participate meaningfully and are not outshot by majorities. It creates objective evidentiary standards. We had objective evidentiary standards from the courts. If that was applied in Parliament, that we don't know. But if that was agreed to in terms of rules, we will know what we are facing in terms of what evidentiary standard are we going to abide with. Finally, it builds a stable constitutional precedent. A predictable framework helps future impeachment processes remain consistent, credible, and less destabilizing to governance. A stable constitutional precedent can only emerge where constitutional values are treated as binding rules rather than aspirational rhetoric. If foundational values of the Constitution are understood as enforceable obligations, they naturally demand structured, predictable procedures whenever the most serious constitutional powers, such as impeachment, are exercised. In this way, fidelity to constitutional values become the anchor for consistency, ensuring that future impeachment processes are guided by principle instead of political expediency, and that governance remains stable, credible, and firmly rooted in the rule of law. The reasons for a rule-based impeachment process. There are no rules. In terms of the constitutional values at play, this court is going to make a decision for expediency. This is not just any other decision. Constitutional values are not decorative. They are not mere suggestions on the walls. They are binding obligations. These are our pillar stones, and these values that we have in the Constitution, such as the rule of law, due process, constitutionalism, accountability, transparency, separation of powers, are a must. They are inextricable. So when impeachment procedures occur without procedural law, clear procedural law, Parliament is no longer implementing the Constitution. It is operating outside it. And I dare confidently, with all the strength from my ancestors from Nyahera in Kisumu, say this, that impeachment is not a political ritual. It is a constitutional trial. May I repeat this for members of the National Assembly? My senator from Kisumu is here. Impeachment is not a political ritual. It is a constitutional trial. So without procedure, the process becomes arbitrary, and this directly undermines constitutional supremacy. That is one. Number two, the rule of law requires procedure. Power cannot operate in a vacuum. The rule of law means that power must be exercised through known, predictable, and fair procedures. We are extending time for you till Saturday. No, we are continuing with the impeachment immediately, irrespective of whether you're present or not. That is rule by man, not rule of law. Failure to have procedural law in the context of this impeachment meant this, that we did not have clear, predictable rules of evidence. That is one. The burden of proof, if at all it existed, kept on being a moving target. There was no right of defense. It was never guaranteed in the first place. People wanted to finish with what they wanted to do and move on. There are no clarity in terms of timelines, fairness, or impartiality. This creates a dangerous precedent where decisions depend on political discretion, not law. The process becomes rule by numbers, not rule of law. And in constitutional theory, absence of procedure means absence of legality. May I repeat that? Absence of procedure means absence of legality. Number three, impeachment is a quasi-judicial process, not a political vote. That term quasi-judicial has been used a lot here. But what is exactly meant by quasi-judicial? In my other life, I'm a member of the academy, and I see two senior members of the academy here. They can confirm that, and may God bless them in advance. Professor Jenda, Professor Guido Muigai, senior members of the academy. Quasi-judicial power means this, that this is the power to determine disputes or making findings affecting the rights of individuals, similar to the way courts operate. What was at stake during the impeachment? A validly elected deputy president of the Republic was going to be impeached. His rights personally and the rights of his many supporters, those who voted for him as part of a ticket, were going to be affected. The consequences are there in terms of the quasi-judicial power. The removal of a deputy president being a very serious constitutional action. It has consequences for the electoral will of millions of voters, stability of the executive, continuity of government. And because of this gravity, impeachment must meet quasi-judicial standards. Quasi-judicial standards, these are the principles of good governance. I don't want to go through the whole list, but again, members of the Academy, Professor Don Oliver has reduced the principles of good governance into 4. Very quickly, these are legality, procedural propriety, rationality, and proportionality. The Oliverian quadrant: legality, procedural propriety, rationality, proportionality. When this court retires, we pray that you are going to consider those 4 principles. This process, as has been brought out by the first petitioner, do they meet the tests of legality? Do they meet procedural propriety in whatever guise? Does it mean rationality? Again, Professor Gender should be familiar with Wednesbury degree rationality. That's a test.
Counsel, address the court, not the Academy.
Most obliged. Most obliged. Most obliged. If I veer into the Academy, please forgive me. Most of the time, I veer towards the Academy. Wednesbury rationality. Has the Wednesbury rationality test been met in terms of this particular impeachment process? Proportionality. Look at the allegation on, for example, what was said and what ought to have been referred to the NCIC, the National Cohesion Committee. Was that proportional? Does it meet the proportionality test? And on that very issue, Senior Counsel Paul Buite submitted to it. There's the principle of subsidiarity that is captured under Section 15 and Section 26 of the NCIC Act. Parliament ought to have deferred to the authority of the NCIC on the allegations made against the Deputy President. NCIC ought to have made the primary decision on the gravity or lack thereof of what was said. So the assumption of Parliament without going to the NCIC is not only illegal and unconstitutional, it also offends the principle of subsidiarity. When Parliament conducted itself in the manner it conducted itself, Parliament acted as the Hobbesian Leviathan. It became the investigator, the prosecutor, the judge, and the jury. This violates Article 47, principles of fair administrative action, and judicial action, quasi-judicial action. Procedural fairness protects the people, not just the office holder. Impeachment is often framed as an accountability of one individual, but constitutionally, impeachment protects the voters who elected that office holder. If procedure is absent or conducted in the manner it was conducted in this case, the electorate's choice can be overturned by unregulated political processes. This weakens popular sovereignty, a core constitutional value. Thus, the real victim of procedural failure is democracy itself. Whereas it protects, there are protections for the individual, the real protected target is the core principle of popular sovereignty. 5, the absence of procedure invites a constitutional crisis. Why? Because without procedure, courts are forced to intervene, parliaments claim political privilege, the executive legitimacy becomes contested. We have a deputy president who did not come through the ballot. That's a legitimate question. Institutional conflict arises between the arms of government. And this leads to the usual talk: judicialization of politics, politicization of constitutional processes, public loss in institutions. A constitutional democracy cannot survive when removal of national executive and office holders lack legitimate legal guardrails. 6, separation of powers demands legal boundaries. Parliament has the power to impeach, but not without limits. Parliament becomes a judge in its own course without procedural law. Checks and balances collapse majority power replaces constitutional restraint. Remember, we are a state under constitutional restraint, not abundant political power. The way in which this impeachment process was conducted contradicts the idea that constitutional supremacy restrains political majority. That is something we will invite you to find. The rules of natural justice, there are three. The right to be heard, freedom from bias, and those have been submitted to. Then there's the third rule, the rule in R versus Sussex, Justices Ex parte McCarthy, 1924. And this rule, as articulated by Lord Justice Hewitt, simply says this, that justice must not only be done, but manifestly and undoubtedly it must be done. Justice must not only be done, but manifestly and undoubtedly it must be seen to be done. In terms of this process of impeachment, the process has continued when the substantive subject of impeachment was in hospital. He did not have the opportunity to rebut or to respond to the charges. In terms of the third rule, the first two were submitted to. I focus on the third rule. R versus Sussex Justice Magistrates. Justice must not only be done, but must be seen to be done. Do we see justice to have been done in this context when somebody was sick in hospital and processes continue without him being present? It's a problem. Precedent danger. Today's deputy president, tomorrow's democracy. If impeachment can continue and happen in such a shambolic manner that it happened, future removals will be done and can be done more easily. The threshold for removing elected leaders becomes political convenience. My brother Ochiel gave us the history. I don't want to go through it. Political convenience brought us to where we are in terms of shielding the office of deputy president. Executive stability becomes fragile. This transforms impeachment from a constitutional safeguard into a political weapon. Is that what we want in terms of this court? In terms of the jurisdiction of this court, I have completed with the rules of procedure. I want to go to the jurisdiction of this court. The High Court has 4 jurisdictional capacities under Article 165. The High Court has original jurisdiction, appellate jurisdiction, supervisory jurisdiction, and writ jurisdiction under Article 165. At play, particularly with regards to the matters before this Honorable Court, are the supervisory jurisdiction and the writ jurisdiction of this court. The supervisory jurisdiction becomes particularly important under Article 165(6), when supervising quasi-jurisdictional capacity of various arms of government. And this is where the court will invoke its judicial review power or judicial review authority. What is judicial review? Judicial review has 2 limbs to it. Judicial review is the primary judicial function to preserve legal order by confining the political branches to their proper limits of power under the Constitution. That's the first limb. The second limb is protection of private individuals by preserving or preventing illegal encroachment on the rights of these individuals. Those are the 2 capacities of judicial review. And when the High Court, under Article 165 of this Constitution, stands as the primary guardian and interpreter of the Constitution and its values, the court exercises broad authoritative jurisdiction, including supervisory and constitutional oversight over the National Assembly. So that the National Assembly will not be hard to say that this is a political question beyond the reach of the court. This court the breadth of its constitutional and supervisory jurisdiction is a capacity granted by the Constitution, and it's not an intrusion into the domain of the legislature, and is a necessary feature of constitutional design. I here telepathically, and I can almost predict that you will hear this from the respondents, that Parliament has its right to formulate its own procedures. If the courts will be inclined to find it that way, we have provided to you a case, Maneka Gandhi versus Union of India, 1978. And it presents to this court a test. The Supreme Court of India, interpreting Article 21 of the Indian Constitution, speaks of due process in this manner. It says, number one, that procedure as a capacity of due process must be established by valid law. That is condition precedent. That condition adds on to say that even if the procedure is prescribed by law, it should be fair, just, and reasonable. Fair, just, and reasonable. So when you retire to write your judgment and you are satisfied that there was a modicum of procedure, you will have to look at that procedure in terms of the Maneka test. Was that procedure fair? Was it just? Was it reasonable? Was it reasonable to continue with the process when somebody is at the current hospital getting treatment? That is a question you will have to answer. In conclusion, a determination of impeachment is not a routine judicial exercise. It lies at the crossroads of law, constitutional governance, and the stability of democracy itself. La santé de notre politique, as the French say, the stability of democracy itself. The court's voice in this moment is not confined to the litigants before it, but resonates to the nation and future generations. This is a modern moment. Your judgment will either confirm that constitutional authority is bound by the discipline of law, or suggest that the most serious constitutional processes may unfold without the safeguards of the Constitution as required. By carrying out this solemn responsibility, the court protects the supremacy of the Constitution, sustains public confidence in democratic institutions, and ensures that the exceptional power to remove a constitutional office holder is exercised strictly within the confines of the rule of law. Nunca más, never again, should we go to the dark old ages. I submit. My brother Sakimpa joins in next.
Thank you.
Yes, Your Lordships and my lady, my name is George Sakimpa. We do appear together with Mr. Ogada for the 4th to 8th petitions. Your Lordship, the petition that is before you is originally Kerugoya petition E015, and which has since been consolidated in these petitions. So, Your Lordship, I will only deal with 2 issues, because I do not wish to regurgitate what my seniors have already said. So, Your Lordship, I will just handle 2 issues, the first one being on the element of public participation, and it is going to be in twofold. That is from at the impeachment level, and secondly, public participation in terms of the appointment of the Deputy President, Professor Kithure Kindiki. And the second issue, Your Lordship, is on the Senate, and whether it was open for the Senate to apply the plenary Road. So, Your Lordship, I will start with the first issue of public participation. Your Lordship, the principles of public participation have already been eloquently espoused here, especially the BAT Supreme Court case. So, Your Lordship, I will not delve into that, other than to add that there is an international association for public participation, which has since developed at least 7 core principles when it comes to public participation. Your Lordship, Kenya, under Article 2.5 of the Constitution, general principles of international law do form part of Kenyan law, and therefore we do rely on those provisions. And there are 7 principles, and basically they have been well captured in the Supreme Court case of BAT. So, Your Lordship, so I would not wish to mention the 7 of them, other than to be referring to them when it is necessary. So, Your Lordship, the most important element of this public participation is that it has to be qualitative and quantitative. So, Your Lordship, what I'm going to do in these short submissions is to go to the evidence and to actually demonstrate that the public participation